Welcome everyone, I'm Russell Alexander. I've been practicing law with the team here at Russell Alexander Collaborative Family Lawyers for over 20 years now. We help families that are going through a separation or divorce. Without further ado, let's get into today's topic. Locations during a pandemic. What's considered substantially more convenient? In light of the ongoing COVID-19 pandemic, when Zoom trials and court hearings are the norm, how should courts determine geographically which family court jurisdiction is most appropriate for adjudicating a legal dispute between spouses? By way of background, the Ontario Family Justice System sets out a procedural etiquette contained in the family law rules that govern various aspects of the legal process. For example, the rules state that a spouse or a parent who wants to commence a legal proceeding against the other should generally do so in the jurisdiction where either of them resides. If the case deals with the custody of or access to children, then the proceeding should usually be commenced in the municipality where the child ordinarily resides. Even in normal times, that choice may not be the most convenient or practical in absolutely all scenarios. Newly separated spouses may now live in different cities, for example, or their flexibility around court attendances might be impacted by the fact that there are children and parenting obligations in the mix. The rules accommodate this by allowing the choice of location to be challenged in some circumstances. This is known as a motion to transfer, and it requires that a requesting party meet certain tests. If he or she is successful, the court can order that the existing legal proceedings are to be transferred to a court in another appropriate city or region. One of the key thresholds for this is that it is shown to be substantially more convenient to make the geographical transfer requested. In a pair of recent Ontario court rulings, the court demonstrated a willingness to view that test through the lens of the COVID-19 pandemic, and in light of all the necessary adjustments to the hearing processes that have been prompted by it. If you're enjoying this video and find it helpful, you can give us a thumbs up or leave a comment in the box below. In the case of Berta v. Berta, the spouses had two separate but intertwined actions marching in tandem through the family court system in different cities. One in Hamilton, where the husband lived, and another in Milton, where neither of them lived. The husband had commenced some of his litigation in Milton, apparently for strategic reasons. The wife, who lived in the South Bruce Peninsula area, asked the court to order that the Milton matters be transferred back to Hamilton. In entertaining this request, the court reflected on the comments in another recent case of Brose v. Stevens. There, the matter was started by the mother in Welland, even though the father had lived in Toronto with their children. Both claimed that they could not afford to travel to court in the city inhabited by the other, and the father asked to have the entire matter switched to where he was located. In declining to grant that order, the court in Brose considered the substantially more convenient test. In light of some of the procedural adjustments wrought specifically by COVID-19 pandemic, the court stated the court no longer requires the parties to travel to motions or necessarily to trials. The trial in open court on this matter is not likely. The court in the Berta drew from this earlier observation in Browse, agreeing that COVID-19 had rendered geographical challenges to be less of a concern now than in the past. The litigation would likely proceed remotely, but should nonetheless be centralized to one of the two cities. In this case, it was Hamilton, as the wife requested. The court explained that the COVID-19 pandemic has forced the court system to discover that with the advent of video technologies, geographic distance isn't nearly as relevant as it used to be. A, the husband is correct that he could quite easily participate in a hearing in Hamilton by Zoom. B, the husband could just as easily participate in a hearing in Milton by Zoom. C, the motion wasn't about whether a standalone motion should be heard in one city or another. D, the issue is whether a second motion should change would be more conveniently and appropriately heard at the same time in the same location as closely related to the first motion to change, which had been ongoing in other cities since 2017. E, should the aspects of spousal support be argued once in one city or twice in two cities? The court ultimately chose the former, i.e. once in one city, and made the order to transfer accordingly. To learn more about these cases, you can read the full case in the link below in the description we have provided. Please leave your thoughts and questions and comments in the comment box below. If you liked this video and found it helpful, please give us a thumbs up and let us know. You can subscribe to our channel and hit the bell icon to get notification every time we upload a new video. Thank you for watching.